Tonight, we begin with an announcement that immigration attorneys had anticipated, predicted, and carefully monitored. An advancement that unfolded not over quarters, but in a single monthly bulletin. A single bulletin that changed the trajectory for thousands of Indian professionals. A single bulletin that opened doors that had been locked for over a year. A single bulletin that sent law firms scrambling to contact their clients. What the Department of State did on December 17th crossed a threshold that immigration experts had hoped would finally arrive. And when that bulletin dropped, applicants did not hesitate. They responded with relief, urgency, and immediate action. For 18 months now, there had been whispers, not official announcements, not formal projections, just whispers, that the Department of State was preparing something unusual for India's EB-1 category. The EB-1 backlog has been persistent, yes, but it has been predictable in its persistence. Its movements have followed a certain rhythm, a pattern, almost a formula. But what set off alarm bells in immigration law offices across America this December was that the pattern went silent. Immigration attorneys who monitor visa availability know the indicators. The quarterly adjustments that typically show minimal movement. The conservative estimates that protect against retrogression. The cautious advancement of just weeks or months. The sudden absence of any pre-bulletin commentary. All of that went quiet. And whenever the Department of State goes quiet before a bulletin release, it means something dramatic is about to get loud. Early December 17th, the State Department released what they described as the January 2026 Visa Bulletin, including priority date movements that had not been seen in over 3 years for the India EB-1 category. These are the kinds of advancements that the department only makes when they are signaling something very specific. Lower than expected visa usage, surplus visa number availability, or a deliberate policy shift to clear backlogs. Immigration experts didn't know which category this fell into, or whether it fell into all three at once. But what they did know was that the State Department was changing its approach to employment-based immigration. And when federal agencies shift immigration policy without extensive preliminary announcements, even by 11 months, the legal community pays attention. The numbers told an extraordinary story. India's EB-1 final action date advanced from March 15, 2022 to February 1, 2023. A jump of nearly 11 months. This wasn't the typical 1 week or 1 month advancement that applicants had grown accustomed to enduring. This was a leap. China's EB-1 category also advanced, though more modestly, moving from January 22, 2023 to February 1, 2023, bringing both countries to the same priority date for the first time in recent memory. The advancement announced by the Department of State this month was not normal. It was not routine. It was not incremental. It was transformative. Immigration attorney after immigration attorney described the State Department's move as unprecedented in recent years, strategically timed for the start of the second fiscal quarter, and perhaps most importantly, indicative of systemic capacity to process more applications than previously demonstrated. But opportunity only works if applicants act quickly. Thousands did. In fact, their response in the weeks following the bulletin release was among the most coordinated we've seen in employment-based immigration. Here's what we know. Within hours of the bulletin's publication, immigration law firms launched mass notification campaigns to their India EB-1 clients. These weren't the standard monthly updates. These were urgent action alerts. Communications that immigration firms only send when they are preparing to file hundreds of adjustment of status applications simultaneously. This month, multiple immigration law sources confirmed that USCIS announced it would accept adjustment of status filings based on the dates for filing chart, including priority dates for India EB-1 that had recently been advanced to August 1, 2023, for what analysts believe was maximizing visa number utilization. Applicants could file, before the State Department could implement any retrogression. They could submit their Form I-485 applications for adjustment of status. They could obtain work authorization and advance parole documents. They could secure their place in line before the fiscal year brought potential backwards movement. In other words, applicants targeted the window of opportunity, the filing window that would have made their green card applications processable. This is what made immigration attorneys' urgency so critical. The State Department's advancement wasn't just symbolic, it was actionable. It represented the kind of movement that could close again if visa numbers were exhausted before September 30th. And applicants, understanding that fully, responded with determination. Not recklessly, not without proper documentation, but strategically. They didn't delay their medicals. They didn't postpone gathering evidence. They assembled complete I-485 packages. They prepared comprehensive supporting documentation. And here's where the story becomes even more significant. Immigration policy analysts now believe that the State Department's latest bulletin was designed to test the processing capacity of USCIS after years of pandemic-related delays. The department wanted to see whether USCIS would become overwhelmed by a surge of filings. But instead, something remarkable happened. The immigration system didn't collapse under the volume. It absorbed the applications with a processing infrastructure that was so expanded, so digitized, that even skeptical observers noticed. You don't get the Department of State's confidence in making massive priority date jumps easily. But this January, they demonstrated it. Immigration consultants speaking with professional networks under confidentiality described the State Department's strategy as demand testing, a way to gauge whether the system could handle accelerated adjudications. But USCIS proved this month that they remain both capable and committed to processing employment-based applications. Their acceptance of the dates for filing chart was not only strategic, it was calibrated so precisely that it allowed maximum filings without triggering system paralysis. That calibration matters because it shows that agencies have learned from past mistakes. It shows that USCIS is not merely accepting applications passively. They are managing immigration inventory actively. As reports continued coming in throughout December and early January, we learned more about the scale of applicant response. Indian nationals with extraordinary ability classifications carried out immediate consultations with attorneys, forcing rapid document preparation across multiple continents. Outstanding researchers and professors targeted their employment verification letters that had been prepared in anticipation of priority date movement in the last 6 months. Multinational managers operating from satellite offices in the United States reportedly finalized their medical examinations used by USCIS to complete the final stages of adjustment applications. This wasn't just individual relief for a few hundred applicants. This wasn't just procedural advancement for a niche category. This was systemic progress for one of the most qualified immigration categories. This was validation of years spent in immigration limbo. And validation is the one thing employment-based immigrants have struggled to maintain since the pandemic disrupted processing timelines. For every month of waiting they have endured, the Department of State has finally countered with something that acknowledges their contributions. Remember, observers thought the India EB-1 category would remain stuck in 2022. They thought China would see minimal movement throughout fiscal year 2026. They thought the Department of State would prioritize family-based categories over employment advancement. But this month, the exact opposite is happening. Employment-based categories are advancing significantly. China and India both reached the same EB-1 priority date. The State Department is demonstrating confidence in accelerated process. What makes this moment so consequential and so carefully watched is that the State Department's latest bulletin happened at a time when immigration policy faces intense scrutiny from multiple directions. Pro-immigration advocates want faster processing and reduced backlogs. Restrictionist voices want stricter enforcement and reduced overall numbers. Business coalitions want talent pipelines maintained for competitive advantage. Tech industry leaders want certainty for their high-skilled workforce. The State Department is balancing these demands while managing statutory visa number limitations. And when federal agencies in that position make sudden moves, they're not doing it from political pressure alone. They're doing it from data-driven capacity assessments. They're doing it from operational confidence that the system can handle the volume. USCIS is announced, and a third warned. Retrogression can happen at any time, and when it does, your filing window closes. These are not rhetorical exaggerations. These are statements from legal professionals who understand just how volatile Visa Bulletin movements can become. Here's what makes the situation even more time-sensitive. The State Department's latest bulletin wasn't the only positive development. Along with India EB-1 advancement, China's EB-2 category also advanced 12 months to December 8, 2018. India's EB-5 unreserved category jumped 10 months in final action dates. The EB-3 other workers category for China saw a massive one-year advancement. All of this happened within the same monthly bulletin cycle. When the State Department moves multiple employment-based categories simultaneously, it means a coordinated effort to reduce backlogs is underway. Immigration analysts are now considering several possibilities. One is that the State Department is preparing for potential legislative changes to per-country caps. Another is that USCIS is attempting to demonstrate its capacity to handle increased application volumes efficiently. A third possibility, the one that concerns applicants the most, is that the State Department is front-loading visa number usage early in the fiscal year, which could mean retrogression later. But this month, applicants who acted quickly took that risk off their personal tables. They didn't assume February would bring similar movement. They didn't gamble that their priority dates would remain current indefinitely. They didn't hesitate when their moment arrived. They filed. USCIS wants to show that years of digital transformation and process improvements have made them more efficient. Immigration advocates want to prevent visa number waste that has plagued the system historically. And applicants want certainty that their years of waiting are finally producing tangible results. This week, we've heard from immigration law firms who are now monitoring February bulletin predictions closely. They say movement may continue for India EB-1, though likely at a more modest pace. They say China could see similar incremental advances across multiple employment categories. And they say the State Department's decision to advance dates so aggressively in January is likely part of a broader fiscal year strategy intended to maximize visa number utilization without triggering mid-year retrogression. But applicants are not sitting idle, waiting for predictions to materialize. In fact, applicants are acting decisively. Their response this month? Immediate, comprehensive, and professionally guided, sent a message to the State Department that demand for employment-based immigration remains extraordinarily high. And it sent a message to USCIS that the immigrant community is prepared to submit complete, approvable applications when given the opportunity. As January continues, we expect more details to emerge about what exactly the State Department's visa number allocation strategy will be for the remainder of fiscal year 2026. But what we do know is that USCIS's acceptance of dates for filing was strategically important. It maximized filing opportunities for thousands of applicants. It provided work authorization and travel flexibility through EAD and advance parole documents. And it demonstrated that the immigration system, despite its many challenges, can still function when agencies coordinate effectively. What happens next will depend on what the State Department does in the February bulletin. If they maintain current priority dates or advance modestly, this January 2026 bulletin will be remembered as the beginning of sustained progress. If they implement retrogression, Applicants who filed in January will have secured their place in line before the door closed. They have shown they are ready to complete the final steps toward permanent residence. And tonight, for the first time in over 18 months, India EB-1 applicants appear to be moving forward meaningfully. Immigration law offices are busy processing applications, too busy to engage in speculation. And when immigration attorneys are overwhelmed with filings rather than consultations, it means applicants are taking action. It means they are seizing opportunities when they appear. Because this month, thousands of highly skilled immigrants learned something they desperately needed to learn. The wait, though long, is not infinite. The system, though flawed, can still deliver results. And opportunity, when it arrives, must be captured immediately. This story is far from over. But tonight, one thing is clear. India's EB-1 category moved forward dramatically. China's multiple employment categories showed meaningful progress. And thousands of applicants who had been waiting years finally have a path forward. And we will be here, watching every monthly bulletin as the next phase of employment-based immigration unfolds.